Welcome back to Deep Dive Daily. I want to start today with a question that sounds like it belongs on a construction site. But stay with me, because it's actually about the very soul of a nation.
Okay, I'm intrigued.
If you build a house, can you renovate it?
I would hope so. Otherwise, you're stuck with that questionable shag carpet from the 70s forever.
Exactly. Or a kitchen that doesn't have a dishwasher. You own the place. You can paint the walls. You can maybe knock down a partition to open up the living room. You can add a sunroom.
Sure, all standard stuff.
But let me ask you this. Can you remove the foundation while the house is still standing?
No, that's not a renovation. That's a demolition. If you take out the foundation, the whole structure collapses.
Let's go.
It ceases to be the house you built. It becomes a pile of rubble.
And that right there is the central metaphor for today's deep dive.
Yeah.
We are looking at Chapter 11 of our source material, titled Basic Structure of the Constitution.
Oh, okay.
This is the story of a decades-long legal tug-of-war to decide just how much of the Indian Constitution could be changed by its parliament.
It is a fascinating journey. It's essentially the legal story of how India decided that while Parliament has the power to change laws and even amend the Constitution itself to keep up with the times, there is a limit.
There's a line you can't cross.
There is a foundation that cannot be touched.
It's a battle between two giants, really. On one side, you have the Parliament, representing the will of the people, the elected majority, who want the power to change laws.
And on the other side, you have the Supreme Court, the unelected guardians, trying to protect the original intent and, the rights of the citizens.
Exactly.
So our mission today is to trace this timeline. We're going to look at the specific historical cases, the amendments, specifically the 1st, 24th, 39th, and 42nd, and the legal arguments that led to the judicial invention of the Basic Structure Doctrine.
A doctrine that basically says some parts of the Constitution are off limits, even to the people who write the laws.
Even to the lawmakers themselves. That's the core of it.
So let's unpack this. We need to go back to the beginning. The Constitution comes into force in 1950. It's this massive document full of hope. Everyone is happy. But it didn't take long for the first conflict to arise, did it?
Not long at all. We are talking about 1951, just 1 year later.
Wow.
You have to understand the context.
Yeah.
India is a new republic, and the government, led by Jawaharlal Nehru, has a massive agenda. They want to implement land reforms. They want to abolish the zamindari system, which was this, sort of feudal way of holding land.
Right. A few people own everything.
Exactly. They wanted to redistribute land to the tillers.
Which sounds like a noble goal for a new democracy focused on social justice.
Absolutely. But there was a constitutional hurdle, a big one.
Which was?
To redistribute land, you have to take it away from someone who currently owns it. And at that time, the Constitution guaranteed the right to property as a fundamental right.
Ah, okay. I see the problem.
So when the government tried to take the land, the wealthy landowners went to the high courts and said, hey, you can't do this. The Constitution protects my property.
And the courts agreed with them.
The high courts started striking down these land reform laws. They said, you cannot violate a fundamental right. It's right there in the text.
So the government is stuck. They have a mandate from the people to fix the land system, but the Constitution is standing in the way.
Precisely.
Yeah.
So what does Parliament do? It passes the First Amendment Act in 1951. They basically want to curtail the right to property to get these reforms done.
But can they do that? Can they just rewrite the fundamental rights?
That was the million-dollar question in the Shankari Prasad case of 1951. The constitutional validity of that First Amendment Act was challenged.
Okay.
And the legal argument revolved around two specific articles of the Constitution, Article 13 and Article 368.
Okay, let's get technical for a second, because this distinction is crucial for everything that follows. I want to really understand the nuts and bolts here. What do these two articles say?
Let's look at Article 13 first. You can think of this as the shield.
The shield, okay.
Article 13 defines what a law is, and it explicitly says that if a law violates fundamental rights, it is void. It's invalid. It essentially says the state shall not make any law which takes away or abridges the rights conferred by this part.
Sounds pretty clear. It's a protective barrier. If Parliament makes a law that takes away my free speech or my property, Article 13 says, nope, you can't do that.
Exactly. But then you have Article 368.
And if Article 13 is the shield,
Article 368 is the sword. This is the article that gives Parliament the power to amend the Constitution.
right.
So the government's lawyers came up with a very clever argument. They argued, hey, a constitutional amendment isn't just an ordinary law under Article 13. It's different.
How is it different?
They said that when Parliament passes a regular law, like a traffic fine or a tax code, they're using legislative power. But when they amend the Constitution, they're using constituent power.
I see. So they're saying there's a hierarchy. There's a difference between passing a regular bill and changing the holy book itself. One is a law, the other is something higher, a constituent act.
That was the argument. They said that because an amendment is an exercise of constituent power, it does not qualify as a law under the definition in Article 13.
And if it's not a law,
Then Article 13's restriction doesn't apply to it.
that is a very clever lawyer's trick. It's not a law, it's an amendment, so the rules for laws don't apply. And did the Supreme Court buy this?
In 1951, in the Shankari Prasad case, yes, they did.
They did.
The Supreme Court agreed with Parliament. They ruled that the word law in Article 13 refers only to ordinary laws. It does not include constituent laws, which are the constitutional amendment acts.
Wow. So effectively, the court gave Parliament a blank check in 1951.
In a way, yes.
Yeah.
The ruling meant that Parliament could legally take away or abridge any fundamental right by enacting a constitutional amendment, and Article 13 couldn't stop them.
So if they wanted to remove free speech via an amendment, theoretically, under this ruling, they could.
Theoretically, yes.
That sets a very specific tone for the early years of the Republic. It basically says that the Bill of Rights, part of the Indian Constitution, was flexible.
Very flexible.
It existed only as long as the Parliament wanted it to exist.
Correct. And for a while, this wasn't a huge problem because the people in Parliament were largely the same people who wrote the Constitution, the freedom fighters. There was a trust that they wouldn't abuse this power.
But as we know, legal history is rarely a straight line. Power dynamics change. So let's fast forward.
About 16 years.
It's 1967. The political landscape is fracturing, single-party dominance is fading, and the Supreme Court is about to change its mind.
The vibe definitely changes. We arrive at the Golak Nath case in 1967. This is a landmark moment, a complete reversal.
What triggered this one? Was it more land reform?
Yes. It was a challenge against the 17th Amendment Act of 1964. This amendment had inserted certain state acts into the Ninth Schedule.
Okay, we need to pause on the Ninth Schedule because it sounds a bit ominous.
It sounds like a vault in a bank,
Right.
and that is a perfect analogy. The Ninth Schedule was created by that First Amendment back in 1951. It's a list at the back of the Constitution, and the rule was, if Parliament puts a law into this list, into this vault, the courts cannot touch it.
It's shielded.
It is shielded from judicial review.
So Parliament was taking laws that might be unconstitutional, throwing them into the Ninth Schedule vault and saying, now you can't check them.
Exactly. It was a safe harbor for laws that violated fundamental rights.
Huh.
And by 1967, the Supreme Court looked at this practice and said, hold on a minute, this is going too far.
So in Golak Nath, they revisited the Shankari Prasad ruling.
They did. An 11-judge bench sat to hear this case. And by a slim majority of 6-5, the Supreme Court completely reversed its 1951 stance.
A 6-5 split. That's a razor-thin margin for such a huge decision.
It was a 180-degree turn.
They didn't just tweak the rule, they threw the old rule out.
Completely. They ruled that fundamental rights are not just lines on a paper that Parliament can erase whenever they have a majority. They used very dramatic, almost philosophical language.
What did they say?
They declared that fundamental rights are given a transcendental and immutable position.
Transcendental and immutable. That sounds almost religious, like these rights are sacred.
It implies they are above and beyond the reach of political majorities. The court ruled that Parliament cannot abridge or take away these rights, period.
And what about the argument from 1951? The whole amendment isn't a law loophole.
They closed it. They ruled that a constitutional amendment act is a law within the meaning of Article 13.
There's the checkmate.
That's it.
So if an amendment is a law, and Article 13 says no law can violate fundamental rights, then Parliament cannot amend the Constitution to take away rights.
Precisely. In 1967, the court effectively told Parliament, you can touch other parts of the Constitution, maybe change the administrative details, but the fundamental rights are off limits. Don't touch them.
I can imagine that didn't go over well with Parliament.
Not at all.
They've been told for 16 years they have this power, and suddenly the court says, actually, no, you don't.
It did not go over well at all. You have to understand the psychology here. Parliament sees itself as the supreme representative of the people.
We were elected, you weren't.
Exactly. If the people vote for a government that wants to change the Constitution to achieve social goals, they believe they should be able to do it. They viewed the Golak Nath judgment as the judiciary stopping the will of the people.
So Parliament strikes back. This is Section 3 of our outline. It sounds like an action movie, but the weapons here are legal clauses.
That's a good way to put it.
This leads us to 1971 and the 24th Amendment.
The 24th Amendment Act of 1971 was a direct, aggressive reaction to the Golak Nath judgment. Parliament basically said, oh, you think the Constitution doesn't give us the power? Fine, we'll change the text of the Constitution to explicitly say we have the power.
That's a bold move. They're rewriting the rule book to win the game.
They amended Article 13 and Article 368, specifically to dismantle the court's argument. The 24th Amendment declared two things very clearly.
Okay, what were they?
First, it said Parliament has the power to abridge or take away any fundamental right under Article 368.
Just in case there was any doubt, yes, we can take your rights. They put it in black and white.
And second, to bypass the Golak Nath logic, they explicitly stated that such an amendment act will not be considered a law under the meaning of Article 13.
So they literally wrote into the Constitution. By the way, Supreme Court, what you said in Golak Nath about amendments being laws, we are writing it down here that they are not laws.
It was a direct power move, a legislative smackdown. They were asserting parliamentary sovereignty. They wanted to ensure that no court could stand in the way of their amendment power.
So in 1971, we are back to square one, but even more intense. Parliament has asserted total control. The court has been overruled by the legislature. This tension is building up to something massive.
And that explosion happens in 1973. This leads us to the most famous, most cited, and arguably the most important case in Indian constitutional history.
The Kesavananda Bharati case.
The big one.
I feel like we should have a drum roll here. Kesavananda Bharati versus State of Kerala, 1973. Even people who haven't studied law have heard this name. Who was he?
Kesavananda Bharati was the head of a religious math or monastery in Kerala. He challenged the government's attempts to manage his property. But like many of these cases, his individual grievance became the vehicle for a much larger question.
The question was huge.
The question before the court was the 24th Amendment valid? Does Parliament have the power to take away rights, or don't they? It was a showdown.
This wasn't just a regular hearing, was it? The scale was different.
No. This case was heard by a bench of 13 judges, the largest bench ever constituted in the Supreme Court of India.
13.
They heard arguments for 68 days. It was a marathon.
And the ruling wasn't a simple yes or no. It was more of a yes, but.
Exactly. It was a brilliant, complex compromise. The judges were split 7-6, but the majority opinion charted a new path.
So another incredibly close decision.
Very close. And first, the Supreme Court overruled Golak Nath. They agreed with Parliament on one big thing. They upheld the validity of the 24th Amendment Act.
Okay, so they conceded that Parliament does have the power to amend fundamental rights. That seems like a win for the government.
It was, on the surface. They said Parliament is empowered to abridge or take away fundamental rights. But UT, and this is the biggest but in Indian legal history, they laid down a brand new doctrine.
The Basic Structure Doctrine.
Yes. The court ruled that while Article 368 gives Parliament constituent power, that power is not unlimited. It does not enable Parliament to alter the basic structure or the basic features of the Constitution.
Going back to our house metaphor, the court told Parliament, look, you own the house, you can knock down walls, you can change the roof, you can repaint the nursery, you can even mess with the fundamental rights room, but you cannot touch the foundation.
That's it exactly. You cannot destroy the identity of the Constitution.
Because then it's not the same house anymore.
If you change the basic structure like democracy, secularism, the rule of law, it ceases to be the Indian Constitution. It becomes something else entirely. And you don't have the power to do that. You have the power to amend the Constitution, not to destroy it and replace it with a new one.
This is genius because it avoids the rigidity of Golak Nath, where nothing could be changed and reforms were stalled, but it stops the total dominance of Parliament we saw after 1971.
It restores the balance. Parliament has power, but it's a limited power. The court found a middle path.
But here's the catch. In 1973, did they actually write down a list of what constitutes the basic structure? Like, did they say, here are the 10 things you can't touch?
No, they didn't. And that's the beauty and the frustration of it. They left it open-ended.
So they didn't define it.
It was a concept, a principle, not a rigid list. They essentially said, we'll tell you what the basic structure is when we see you trying to break it.
Which means this doctrine gave the Supreme Court immense power. They became the final arbiter of what the spirit of the Constitution is.
Absolutely.
And this doctrine had to be tested immediately. It didn't take long, did it? We're moving to Section 5, the election case in 1975.
This was a very turbulent time in Indian history. We are entering the period of the emergency. This is the Indira Nehru Gandhi case, often called the election case.
Right.
The context is vital here. Prime Minister Indira Gandhi had been found guilty of electoral malpractice by the Allahabad High Court, and her election was declared void.
So her job was on the line. She was about to be removed from office.
Yes. And while her appeal was pending in the Supreme Court, Parliament, which she controlled, passed the 39th Amendment Act of 1975.
What was in this act? What did it do?
It was incredibly specific. Among other things, the 39th Amendment contained a provision that said election disputes involving the Prime Minister and the Speaker of the Lok Sabha were outside the jurisdiction of all courts.
Wait. So if there's a dispute about whether the PM was elected fairly, the courts aren't allowed to look at it.
That's what the amendment said. It tried to place those specific offices above judicial scrutiny regarding their elections.
So it was a law for one person, basically.
It essentially said the law applies to everyone else, but not to these two people.
That seems to fly in the face of equality. Everyone is equal, but some are more equal than others.
And that's exactly what the Supreme Court seized upon. They applied the brand new Basic Structure Doctrine. They invalidated that specific provision of the 39th Amendment.
On what grounds? What part of the foundation did it break?
They argued that free and fair elections and the rule of law are part of the basic structure.
Makes sense.
If you take away the court's ability to adjudicate an election dispute, you are damaging the mechanism of free and fair elections. You are destroying the rule of law by saying the law doesn't apply to certain individuals in the same way.
So even though Parliament followed the correct procedure to pass the amendment, they had the majority, they did the paperwork, the content of the amendment was invalid because it broke the foundation.
Correct. This was the first time the Basic Structure Doctrine was used to strike down a constitutional amendment. It proved that the doctrine wasn't just a theory, it had teeth.
But Parliament didn't give up, did they? They tried one more massive push. This is Section 6, Total War, the 42nd Amendment.
Well, the 42nd Amendment Act of 1976 is often called the mini-constitution because it changed so much. It was passed during the emergency. But for our story, the most relevant part is how it amended Article 368 again.
Parliament seems obsessed with Article 368. They just keep going back to it. What did they do to it this time?
They wanted to bury the Basic Structure Doctrine once and for all.
They're good.
The amendment declared that there is no limitation, none whatsoever, on the constituent power of Parliament. And it explicitly stated that no amendment could be questioned in any court on any ground.
Any ground. Even if it violated fundamental rights. Even if it turned India into a dictatorship.
The text said, on any ground. They basically put up a do not enter sign for the Supreme Court on the entire Constitution. They were asserting absolute supremacy.
That is a direct challenge. We are supreme, you can't touch us. How did the court respond?
This brings us to the Minerva Mills case in 1980. The emergency was over, democracy had been restored, and the Supreme Court had to deal with this amendment.
And the logic the court used here is just, it's beautiful logic. I want you to walk us through it slowly.
It really is elegant. The court struck down that provision of the 42nd Amendment. Their reasoning was this. The Constitution gives Parliament the power to amend.
Right, from Article 368.
But that power was given by the Constitution, which is a controlled document. Therefore, the power to amend is a limited power.
Okay, I follow. The Constitution is the source of the power, so the power cannot be greater than the source.
Exactly. And this is the key line. The court said, a limited power cannot, by the exercise of that power, convert the limited power into an unlimited one.
I love that. The done of a limited power. Let's use an analogy. If I lend you my car, I give you limited power over the car. You can drive it, you can park it.
Right.
But you cannot use that power to drive the car to a dealership, sell it, and buy a jet plane.
That is a perfect analogy. Just because you have the keys doesn't mean you own the universe. The court held that a limited amending power is itself a basic feature of the Constitution.
That's so meta. The fact that Parliament's power is limited is, in itself, part of the foundation.
Yes, because if Parliament had unlimited power, they could repeal the Constitution entirely. They could destroy the democracy. The court ruled that judicial review cannot be excluded because it's the mechanism that checks if the limits are being respected.
So Minerva Mills in 1980 really solidified the doctrine. It put the final nail in the coffin of the idea that Parliament is absolutely supreme.
That's the key takeaway. The Constitution is supreme.
And there was one more case that tidied things up, right?
Yes, just to tidy up the timeline. In the Waman Rao case in 1981, The court clarified something important about when this applies. They said the Basic Structure Doctrine applies prospectively.
Meaning it only applies to amendments made after the date of the Kesavananda Bharati judgment?
Yes, April 24th, 1973. Anything Parliament did before that date is safe. Anything after that date is subject to the basic structure test.
So they didn't want to open a can of worms and undo 20 years of history. They just drew a line in the sand.
Exactly, a pragmatic decision.
Okay, so we've established the history. We've gone from Parliament Supreme in 51 to Right Supreme in 67 to Constitution Supreme via basic structure from 73 onwards.
That's the arc.
But we still haven't fully answered the question, what is the basic structure? You mentioned there's no single list.
That's right. The Supreme Court has never released a master list. It emerges case by case. When a new challenge comes up, the court looks at it and decides, is this particular feature part of the foundation?
But over the years, looking at our source material, we can compile a pretty good checklist of what they've identified so far.
Oh, absolutely.
Let's run through the ingredients of this foundation. What are the bricks that hold up the house?
Sure. Based on various judgments, here are the core elements. First and foremost, the supremacy of the Constitution.
The bedrock.
That's the bedrock. No one is above the book. Then you have the nature of the state. Sovereign, democratic, republican.
Can't get rid of those.
No. And the secular character of the Constitution is also part of the basic structure. You cannot amend the Constitution to make India a theocracy, for example.
That makes sense. What about the way the government is organized?
The separation of powers, legislature, executive, judiciary, you can't merge them. The federal character is also basic structure. You can't turn India into a unitary state where the states have no power.
And we talked about judicial review?
Yes. Judicial review is a basic feature. You can't take away the court's power to interpret the law. Also, the rule of law, that everyone is equal before the law.
There's also some interesting ones about the goals of the nation.
Yes, the welfare state or socioeconomic justice, the unity and integrity of the nation, and harmony and balance between fundamental rights and directive principles.
That last one sounds like a yoga pose, harmony and balance, but it's legally quite heavy. It means you can't emphasize one to the total disruption of the other.
You've got it. And of course, free and fair elections, independence of the judiciary, and the principle of equality.
It's quite a comprehensive list, even if it's not official. It basically covers everything that makes a modern liberal democracy work.
It effectively locks in the democratic, secular, and republican identity of India.
Let's look at how this evolved through specific cases. We have this great table in the source material, Table 11.1, Evolution of the Basic Structure. We've covered the big ones like Kesavananda and Minerva Mills, but there are other bricks in this wall.
Yes, and each case has a specific nuance. For instance, look at the Central Coalfields Ltd. case in 1980.
A coal case. How does that relate to the Constitution?
It sounds mundane, but it established effective access to justice as a basic feature.
What does that mean?
It's not enough to have courts.
Yeah.
People must be able to effectively access them. If the legal system is so expensive or slow that no one can use it, that violates the basic structure.
That's crucial. Then there's the S.R. Bommai case in 1994. This is a huge one for politics.
Massive. S.R. Bommai was primarily about the imposition of president's rule in states, basically the central government firing state governments.
Right.
But in its ruling, the Supreme Court heavily emphasized federalism, secularism, and democracy as basic features.
How did that change things on the ground?
It made it much harder for the central government to dismiss state governments arbitrarily. The court said, federalism is part of the basic structure. You can't just trample on the states. It protected the diversity of the political map.
I see. It protects the states against a bullying center. What about the Indrasani case? That's the famous Mandel Commission case regarding reservations, right?
Yes, 1992 and 2000. While dealing with reservations, or affirmative action, the court established the rule of law and the principle of equality as basic features.
So they were balancing competing principles there.
They ruled that while you can have reservations to help disadvantaged groups, you cannot do it in a way that violates the basic principle of equality or the rule of law.
There's another one here that catches my eye. The Quijado-Holohan case in 1993. The defection case.
This dealt with the anti-defection law, which stops politicians from jumping parties after being elected. The court reaffirmed free and fair elections and the sovereign democratic republican structure. It emphasized that the way our representatives behave and how they are elected is central to the structure.
And jumping forward a bit, look at the I.R. Coelho case in 2007. This is known as the Ninth Schedule case.
This closed a very old loop. Remember back in 1951, we talked about that vault, the Ninth Schedule.
Right, the safe harbor.
Well, in I.R. Coelho, the court ruled that laws placed in the Ninth Schedule after April 24, 1973 are open to challenge if they violate the basic structure.
So the safe harbor isn't so safe anymore.
The vault has a window now. The court identified separation of powers, judicial review, and the principles, or essence, underlying fundamental rights as basic features. Even the Ninth Schedule can't protect a law if it destroys the essence of fundamental rights.
It seems like a court has systematically plugged every hole Parliament tried to dig.
They have. Look at the L. Chandra Kumar case in 1997 and the Madras Bar Association case in 2014. These focused on the powers of the high courts. The court ruled that the powers of high courts under Articles 226 and 227 are part of the basic structure.
So you can't bypass the high courts with special tribunals.
You can't create tribunals that completely strip the high courts of their jurisdiction.
So it's not just the Supreme Court's power that is protected, but the entire judicial system's role in reviewing administration.
Correct. Judicial review is a thread that runs through almost all these cases. The court is adamant that in a constitutional democracy, there must be an independent body to check the actions of the legislature and executive.
It's really a fascinating evolution. We started with a question, can you remove the foundation? And the answer, after 70 years of legal wrestling, is a resounding no.
And it's a detailed no. You can't remove the foundation of secularism. You can't remove the foundation of federalism. You can't remove the foundation of judicial independence.
Let's synthesize this for our listener. We've thrown a lot of dates and case names at them. We went from Parliament having total control in 1951
to zero control over rights in 1967.
To a middle ground where they have control unless they touch the soul of the Constitution from 1973 onwards.
That is the perfect summary. The basic structure is essentially the Constitution's self-defense mechanism. It ensures that while the laws can change with the times, the identity of the nation democracy, secularism, justice remains intact.
It's the difference between changing your clothes and changing your DNA. Parliament can change the clothes, the policies, the taxes, the speed limits, but the court protects the DNA.
That's a brilliant way to put it, and it resolves the conflict we started with. Who is supreme? In 1951, it looked like Parliament was supreme. But the Basic Structure Doctrine clarifies that the Constitution is supreme. Parliament and the Supreme Court are both creatures of the Constitution, and they must operate within the playground it defines.
And that leads us to the provocative thought we promised. This whole doctrine, it's not explicitly in the text, is it?
No, it's not. You won't find the words basic structure in the original 1950 text. It is a judicial invention. It's inferred, not written.
So here's the question for you, the listener, to mull over. In a democracy, we usually think the elected representatives, the parliament, should have the final say because they represent the people. But here we have a doctrine created by unelected judges that limits what the elected representatives can do.
It raises a fascinating philosophical tension. Who should be supreme? The elected representatives or the unelected judges who interpret the text?
The Basic Structure Doctrine says neither.
It suggests the Constitution is supreme over both, and the judges are merely the guardians of that supremacy.
It suggests that to save democracy, you sometimes have to limit the power of the democratically elected. It's a paradox, and it's what keeps constitutional lawyers up at night.
But it's a paradox that has likely saved the Indian Constitution from collapsing under political pressure more than once.
Absolutely fascinating. It turns out you really can't renovate a house by blowing up the basement.
Not if you want to keep living in it.
Thank you for taking us through that journey. If you enjoyed this deep dive into legal history and want to understand more about the hidden foundations of the world around you, make sure to like and subscribe to the channel Deep Dive Daily.
See you in the next deep dive.